right? So center state relationship, and in this we are going to study about the legislative relationship, administrative relationship, and the financial relationship. You know, we have the legislature at union, at state. So on what subject matter the union legislature shall make the laws? On what subject matter the state legislature shall make the laws? What will be the territorial extent? जैसे मान लो दिल्ली में हम on certain matters that except police, law and order, land, Delhi legislature can make the laws. But a law made by the legislature of Delhi, उसकी validity कहाँ तक होगी? So has the boundaries been fixed by the constitution itself? And if they have been fixed by the constitution, then what are their limitations? So all these things we will be studying under the legislative relationship. Now this is a general rule that state वाले अपने में काम करेंगे. The central parliament will make the laws in their own respective domain. What about the other situations? When is the parliament empowered to make laws in the state? Can parliament interfere in the state domain? Is it allowed by the constitution? If yes, then what are those circumstances? So we will firstly see the ordinary situation, what ordinary division of powers which has been given by the constitution. So you will see Article 245, Article 245 to Article 255 talks about the distribution of legislative relationship between. अच्छा दूसरी handout मिल गई आपको? उसमें होगा ये center state relationship वाला in the second handout. I hope in the online also you people have got the second handout. Okay, right. So Article 245 to 55 talks about the legislative relationship. 256 to 263 is administrative relationship. So the legislature has made the laws, then who has the power to execute the law? I am suppose saying that we make a law, NDPS Act, Narcotic Drugs and Psychopathic Substances. जो चरस, हफीम, हेरोइन, कोकीन का तस्करी करते हैं, जहां पकड़े जाते हैं, आर्यन खान जहां गया, NDPS Act. So if that is a law made by the union, who has the power to implement that laws? That means if anyone is found violating those laws, who shall be taking the actions against them? Ordinarily, the law and order is the domain of state police. But in NDPS, we have a special branch which is taking the cognizance of the issue, NCB, Narcotic Controls Bureau, जिसका वो ऑफिसर था समीर वाड़खिड़े, जिसको हटाया गया अभी. So this is the executive part. So Parliament has enacted the NDPS Act, and based upon that, if any implementation has to be done, that will be done by whom? State or the union. And if anyone is found to be violating, it is whose duty to catch the violators and bring it before the court of the law. There is no doubt that any law which is made by the Parliament or even by the state legislature can be adjudicated by any court in India. चाहे वो NDPS का एक्ट हो जो पार्लियामेंट ने बनाया है, या फिर any state act. There are state acts also. For example, take an example of MCOCA, Maharashtra Organized Crime Control Act. You must have heard about दाऊद इब्राहिम, डोंगरी टू दुबई. मूवी आपने देखी होगी, वो अक्षय कुमार और इमरान हाशमी की मूवी, नहीं इमरान खान की मूवी है ना. वंस अपॉन अ टाइम इन मुंबई, दोबारा, पहले वाला भी था, दोबारा वाला भी है. That is based upon his life. There is a novel also called Dongri to Dubai. So this whole era of 1990s and prior to 1990s, late 1980s and early 1990s, जब तक 1993 में बॉम्ब ब्लास्ट हुए, so that was dominated by his syndicate. And to control those kinds of crime, Maharashtra has enacted a special act that is called Maharashtra Control of Organized Crime Act, MCOCA Act, right? So this is an act which is passed by the legislature of the state. But suppose a person who has been caught under the MCOCA has been punished by the local court of Maharashtra, then went into the High Court, his sentence has been maintained. So don't you think that he has the right to appeal in the Supreme Court? But yet a law made by the state legislature is being tried in the Supreme Court. It is possible. Because in judiciary, we do not segregate the things. But in legislative domain, in executive domain, we have the division of power. Who will catch the culprits under a state act? Who will have the responsibility? Who will have the administrative power to implement those laws? So that is given under the administrative relationship, which starts from 256 and goes to Article 263. So administrative relationship 256 to Article 263 we will be dealing about. Then financial relationship, how the resources are to be shared between union and state. We are a federation, but this does not only means the federation in terms of division of legislative powers, but also in terms of division of a sharing of material resource of the country. So there are certain ways of acquiring revenue by the government. Maybe tax revenue or maybe non-tax revenue. That the differentiation you already know. One is by the way of taxation, government can have the revenue. Another is by selling the government entities, disinvestment, sending and giving the loans, taking and giving the loans, government can have their revenues. So there are various modes of acquiring revenues by the government. Union government can also raise their revenue and the state governments can also raise their revenues. But you know, the biggest source of pool of revenue in India is the direct taxes, which includes income tax and corporate tax. These are collected by the union. So if union is getting most of the chunks, most of the finances, then in order to meet their own responsibilities, which has been casted by the constitution upon the states, like maintenance of sanitation, health, public health, education, primary education. So these are the duties of the state. So in order to fulfill these obligations, where they will get the funds from? So they need to be shared. The funds needs to be shared from union to state. Then what will be the principle based upon which? Suppose that union governments get 100 rupees as the total tax. Then how much is to be shared with the states, and how much is to be kept with the states? Who is going to give out this principle? For this, we have a mechanism, we have an authority called Finance Commission of India. That is given under Article 280. The whole gamut of this financial relationship, starting from Article 268 going on to 293. It is talking about financial relationship. So Article 268 to 293. This is about the financial relationship between union and state. In the meanwhile, 256, 266, etc. are the consolidated fund. So we are going to tackle each one of them. Let's start with the legislative relationship. Legislative relationship. Who can make laws for whom? Firstly, you should know about the territorial extent. Territorial extent meaning the law made by the parliament. What is the validity of the law made by parliament? What is the validity of the, what is the extent of the law made by state legislature? So any law which is made by the parliament is valid throughout the country. So they will have the pan-India operation. Parliament can make the law, and that law will be uniformly applied to all the states and to all the territories of India, including union territories and the states. And if any state legislature is making the laws, it is valid till respective states. Now this arrangement is given under Article 245. That says, any law which is made by the parliament shall be valid throughout the India, throughout the territory of India. Any law which is made by the respective state legislature shall be throughout the respective states. But now simply tell me that if there is any law which is made by the state legislature and it is transcending the limit, boundary of the particular state, only for this reason should that law be made invalid. Only for this reason, that it is exceeding the limitations of its own state. Only for this reason. Otherwise the law is very reasonable, otherwise the law is very just and fair. तो जो हम ये डिवीजन ऑफ पावर्स देख रहे हैं ना, कि ये ऐसा करेगी, वो ऐसा करेगी, दिस इज द आइडियल केस सिनेरियो. It is not a black and white division. We know that Parliament can make the laws only on the union list. But don't you think that Parliament can also make the laws in the state list? This is constitutionally possible. This is otherwise also possible. So similarly, if a legislature of Bihar makes the laws, suppose legislature of Bihar make the law that selling, production, manufacturing and storage of alcohol is a punishable offense, right? So Bihar की legislative assembly ने एक act बनाया है, prohibition of liquor act, that says manufacture, storage, selling, etc. of any alcoholic substances is a punishable offense. So anybody within the territory of Bihar is producing the act, producing the alcohol can be punished. Anybody storing the alcohol can be punished. Selling the alcohol can be punished. Now, what if a person from Jharkhand manufactures the alcohol in the Jharkhand, comes and sells to Bihar, and he goes back to Jharkhand? Now, who has committed something that was a punishable offense, but the person is outside the jurisdiction of Bihar. बिहार की लेजिस्लेटिव असेंबली के सब्जेक्ट मैटर कौन है? बिहार की जनता. So here, as per the law made by the Bihar Assembly, police from Bihar goes on and catch the accused from Jharkhand. So can't it be said that there is extraterritorial operation of this law? क्योंकि वो लॉ तो लिमिटेड बिहार तक ही था, बट इसका इंपैक्ट कहां देखना पड़ रहा है? झारखंड में. It may have associated issue. There is a nexus between the law which is made in the Bihar and the person who has committed the crime in the Jharkhand. है ना? रीजनेबल नेक्सस है ना, क्योंकि बिहार में इस लॉ को सक्सेसफुली इंप्लीमेंट करने के लिए उस पर्सन का कैच होना जरूरी है. बिकॉज गवर्नमेंट और लेजिस्लेचर ऑफ द बिहार हैज इनेक्टेड दिस लॉ फॉर ए पर्पस, टू कंट्रोल द अल्कोहलिज्म इन बिहार. दैट इज द ऑब्जेक्टिव ऑफ द एक्ट. व्हाट इज द ऑब्जेक्टिव ऑफ द एक्ट? दैट देयर शैल बी नो अल्कोहलिज्म इन बिहार. Now, to fulfill this objective, there was any action which was taken by the executive, and that has an extraterritorial operation. The action which has been taken as per this law exceeds the limit, the boundary of the state. So primarily it may look that it is not possible, क्योंकि state legislature की capacity उसके अपने territory तक थी. But the matter will go to the court. Supreme Court will decide. This is a dispute between two states कि भाई तुम हमारे स्टेट में कैसे इंटरफेयर कर रहे हो? Your legislature is enacting any law which is transgressing into my territory. So this is a dispute between two states, federal dispute. Supreme Court will see that whether this breach of territory by the legislature of Bihar has been intentionally done just to violate the powers of other state, or is there any nexus between the objective of the act and this breach of powers? Nexus means relationship. Nexus means relationship. So if it is established that there is a reasonable nexus between the objective of the act and transgression of the powers of the legislative competency, अगर लेजिस्लेचर ये सेटिस्फाई कर देती है कि हमने अपने स्टेट की टेरिटरी को सिर्फ इसलिए ब्रीच किया है बिकॉज इन ऑर्डर टू फुलफिल द ऑब्जेक्टिव ऑफ द एक्ट, अनलेस एंड अनटिल वी डू द सेम थिंग, होल ऑब्जेक्टिव ऑफ द एक्ट विल बी डिफीटेड. So if it has been proved that there is a reasonable nexus between the action and the objective of the act will not be declared unconstitutional or void. Otherwise, any act which is breaching the boundary of the state enacted by the state legislature is liable to be declared void. But if it is established by the legislature of the state that there was a sufficient nexus between the objective and the action, then this law will not be declared void. दिस इज नोन बाय अ नेम कॉल्ड डॉक्ट्रिन ऑफ टेरिटोरियल नेक्सस। क्या बोलते हैं इसको? डॉक्ट्रिन ऑफ टेरिटोरियल नेक्सस बोलते हैं। Right? So at this point of time, you know the territorial jurisdiction of union legislature and state legislature. Now, there may be any other situation when a legislation required to be enacted for extraterritorial operation. इंडिया के बाहर के लिए कोई कानून बनाना हो, पाकिस्तान के लिए कोई कानून बनाना हो, हम बना देंगे? नहीं बना सकते. But there may be any act for any person who is of Indian origin for the time being living in Pakistan to regulate his conduct, to regulate his behavior. Suppose that a person who is an Indian citizen has married in India, goes on in America, marries again there, comes back to India. So now as per the law of India, he has committed a bigamy and he should be punished. But this is having another extraterritorial operation. We are trying to punish a person who is not situated in India. Take another example. When partition happened in India, so people from India migrated to Pakistan, but before migrating, they would have certain properties in India. They would have left those properties and then migrated. Those properties are still unclaimed in India. क्योंकि आपकी प्रॉपर्टी है, आप चले गए, मुझे तो वो मिल नहीं सकती, बिकॉज दैट इज नॉट माई प्रॉपर्टी. या तो मैं कब्जा करूंगा, दैट इज एन इलीगल थिंग. सो इन ऑर्डर टू अप्रोप्रिएट दोज प्रॉपर्टी, गवर्नमेंट ऑफ इंडिया और पार्लियामेंट रादर इनैक्टेड वन लॉ, एनिमी एलियन प्रॉपर्टी एक्ट. Now this is impacting the rights and liabilities of those persons who are not situated in India. Then who has the power to make those kinds of laws? It is the legislature of the state or parliament. So it is parliament. Firstly, parliament can make the law which will be valid throughout the territory of India. Secondly, state legislature will make the law concerning to their respective territory. And thirdly, if there is any law which is required to be made for extraterritorial operation, India के बाहर के लिए कोई कानून बनाना है, वो पार्लियामेंट ही बना सकती है. These three principles are given under Article 245. अभी हमने सबका क्षेत्र तो समझ लिया कि on what territory, on what, in how much areas these legislature are going to make the laws. Now next point is on what subject who can make the laws. What are the subject matter distribution? So in this, there is Article 246 coming into picture. Article 246. प्रिलिमिनरी एग्जामिनेशन में सेंटर स्टेट रिलेशनशिप से आजकल बहुत ट्रिवियल क्वेश्चन पूछते हैं. ऐसे फैक्ट निकालेंगे बेयर एक्ट से. Remember this year's question, there was a question that it is the duty of the union to protect the states. ये यूजुअली आप टेक्स्ट बुक्स में, क्लासरूम्स में इस तरह की चीजें नहीं डिस्कस होते हुए देखोगे. बट दिस इज अ प्रोविजन विच इज वेल फाउंडेड इन द बेयर एक्ट, जो आपको बेयर एक्ट में पढ़ने पे मिल जाता है. तो सेंटर स्टेट रिलेशनशिप से ट्रेडिशनली दे हैव एग्जॉस्टेड ऑल द क्वेश्चंस. And if they have to ask factual questions, तो ऐसे ही प्रोविजंस निकालेंगे वो. तो आपकी एक रिस्पॉन्सिबिलिटी बनती है क्लास खत्म होने के बाद ये जो प्रोविजंस हम डिस्कस कर रहे हैं उसके और उसके आसपास के बेयर एक्ट के प्रोविजन आप पढ़ोगे. एक बार में समझ में नहीं आएगा, दोबारा पढ़ोगे नहीं आएगा, तीसरी बार चौथी बार नहीं आएगा. मैं यहाँ पे होता हूँ, ठीक है. बट बेयर एक्ट इज वन थिंग विच इज कॉम्प्लेक्स टू अंडरस्टैंड. इट इज काइंड ऑफ अ लॉयर्स पैराडाइज. बाकी सब लोग नहीं समझ सकते. दिस इज वाई हमारे यहाँ लीगल लिटरेसी कम है, पर कोशिश तो करनी है एग्जाम में अच्छे नंबर लाने हैं. तो आप बेयर एक्ट के स्पेशली द सेंटर स्टेट रिलेशनशिप वाले प्रोविजंस आप जरूर पढ़ना, राइट. सो आर्टिकल 246 टॉक्स अबाउट द डिवीजन ऑफ लेजिस्लेटिव पावर्स ऑन द सब्जेक्ट मैटर. ऑन व्हाट सब्जेक्ट मैटर यूनियन कैन लेजिस्लेट, ऑन व्हाट सब्जेक्ट मैटर द स्टेट्स कैन लेजिस्लेट, ऑन व्हाट सब्जेक्ट मैटर बोथ कैन लेजिस्लेट. So Article 246 says there will be a Schedule 7 in the Constitution. Now, as per this schedule, whatever subjects which are mentioned under union list. So this schedule 7 has 3 lists. One is union list, another is a state list, and another is concurrent list. So as per this schedule 7, there are 3 lists. So under the union list, who can legislate? Parliament. Now you should note that it is exclusive power of Parliament. Parliament includes President, Lok Sabha and Rajya Sabha. So it is the exclusive power of Parliament to enact any law on any subjects which is mentioned under the union list. Generally speaking, the laws like defense, finance, telecommunication, these are the subject matter. Military establishment, railways, preventive detention. Preventive detention is of 2 categories. Preventive detention related to any law of the defense of India, that is under the union list. तो ऐसी सारी चीजें कहां मेंशन्ड है? यूनियन लिस्ट में. So on any subject matter which is mentioned under the union list, Parliament has the exclusive power. Parliament has exclusive power. Now on any subject matter like land reforms, police, law and order, these are the subject matter which are mentioned under state list. ये आपको लिस्ट याद नहीं होगा, करने की भी जरूरत नहीं है, बट क्वेश्चन आ सकते हैं इस पे. आप 2, 3, 4 बार 5 बार जब एक गो थ्रू करोगे ना, जो इंपॉर्टेंट टॉपिक्स हैं, दैट यू विल, वो आपके माइंड में फिट हो जाएगा कि these are certain topics which is mentioned under the union, these are certain topics which are mentioned under state. बाकी करंट अफेयर्स में कुछ आता है वो आप स्पेसिफिकली देख लेना. If there is a dispute on farm bills, someone is saying that it is the power of the state, someone is saying no, it is the concurrent list. तो it is your duty कि जाके देखो कि कौन से लिस्ट में क्या दिया हुआ है. There are 2-3 situations which is related to agriculture, agricultural education, agriculture marketing, फार्मर प्रोड्यूसर ऑर्गेनाइजेशन, ये सब अलग अलग लिस्ट में दिए हैं. सो आफ्टर रीडिंग एनी ऑफ दिस काइंड्स ऑफ करंट अफेयर्स, यू शुड गेट दिस क्लैरिटी कि कौन सी लिस्ट में क्या दिया हुआ है. पूरा आप याद नहीं कर सकते. देयर आर मोर देन 300 सब्जेक्ट मैटर्स. 97 अराउंड 98 है इन यूनियन लिस्ट. आई एम नॉट एक्चुअली रिमेंबरिंग द प्रेजेंट कितना है. ये स्टेट पीसीएस में पूछा जा सकता है कि यूनियन लिस्ट में कितने सब्जेक्ट मैटर हैं, स्टेट लिस्ट में कितने हैं. आपको याद करने की जरूरत है नहीं, वैसे नहीं आ सकता. बट हाँ, इंटरनली यू शुड लुक व्हाट आर द इंपॉर्टेंट सब्जेक्ट मैटर विच इज गिवन अंडर द यूनियन लिस्ट, व्हाट आर द इंपॉर्टेंट सब्जेक्ट मैटर विच इज गिवन अंडर स्टेट लिस्ट, व्हाट आर द इंपॉर्टेंट सब्जेक्ट मैटर विच इज गिवन अंडर कॉन्करेंट लिस्ट. ठीक है. सो अपॉन एनी सब्जेक्ट मैटर विच इज गिवन अंडर यूनियन लिस्ट, पार्लियामेंट हैज द एक्सक्लूसिव पावर. अपॉन एनी सब्जेक्ट मैटर which is given under the state list, state legislative assembly has the exclusive power. Exclusive power means only they can make the laws. In any subject matter which is mentioned under the state list, only state legislature can make the laws. Concurrent list. Now both union and state can make the laws. Union and state can make the laws. नाउ टेल मी, ये दोनों तो क्लियर हैं, यूनियन एंड स्टेट वाले तो क्लियर हैं. इफ देयर इज एनी लॉ, सपोज क्रिमिनल लॉ एज ए सब्जेक्ट विच इज मेंशन्ड अंडर द कॉन्करेंट लिस्ट, बोथ यूनियन कैन मेक द लॉ एंड स्टेट कैन ऑल्सो मेक द लॉ. सो इफ देयर इज अ लॉ विच हैज बीन मेड बाय स्टेट, क्रिमिनल लॉ के किसी एस्पेक्ट पे महाराष्ट्र की असेंबली ने इन 2018 दे हैव मेड अ लॉ. नाउ इन 2022 ऑन द सेम सब्जेक्ट मैटर, ऑन द सेम इशू, पार्लियामेंट इज ऑल्सो मेकिंग अ लॉ इन 2022. नाउ बोथ आर कमिंग इनटू कॉन्फ्लिक्ट विद ईच अदर. द लॉ मेड बाय द लेजिस्लेचर ऑफ महाराष्ट्र सेज समथिंग, the law made by the parliament says something other. Both are conflicting. Remember, the subject matter is under the concrete list. But who has made it previously is the legislature of the state. So whose law shall prevail here? Parliament's law shall prevail. In a case of conflict between a law made by the state legislature and a law made by the parliament, whosoever has made the law previously, it doesn't matter. It is the law made by parliament which will prevail if there is a conflict on the subject matter which is mentioned in the concrete list. So अगर concrete list में कोई subject दिया है, उस पे पार्लियामेंट ने भी लॉ बनाया है और स्टेट की असेंबली ने भी लॉ बनाया है, and both these laws are conflicting with each other. Whosoever has made the law before or after doesn't matter, simply the law made by the parliament shall prevail. Right? अब इस सिचुएशन में एक और एडिशनल फैक्ट डालते हैं. Now let's take that while Maharashtra Assembly made the law in 2018, the governor of Maharashtra had a power then. Either he could assent the bill, he could reject the bill, he could send for the reconsideration, or he could reserve for the assent of the president. उस समय 2018 में गवर्नर ऑफ महाराष्ट्र के पास ये पावर रही होंगी. Now suppose governor exercised the fourth one. गवर्नर ने फोर्थ पावर एक्सरसाइज की. What was that? He reserved the bill for the assent of the president. So this bill of the Maharashtra was reserved for the assent of president. Once it come to the president, president has granted his approval. Now the bill becomes act. Now again in 2022, Parliament is making any law which is conflicting with this law. Which law shall prevail? State legislature. So the rule says, अभी आप समझो, in concurrent list, both union can and state can make the laws. If the law made by union and state are conflicting with each other, the law made by union shall prevail. But if any law which is made by the state was reserved for the assent of the president and the president has granted his assent and then it is conflicting with the law of union, it will not be declared void, it shall prevail. But only within respective state territory. बाहर parliament का law लगे. Clear है? So this is the three basic principles which concerns the division of legislative powers. Now, if any subject matter which is neither given under the union nor in the state, neither in concurrent, who shall make the laws? This is called residuary power of legislation. So, Article 248, it says the residuary power of legislation lies in the hands of Parliament. The residuary power of legislation किसके पास है? Parliament. Residuary power means any subject matter which is not tackled in any of these three lists, neither in union nor in state nor in concurrent, it is to be enacted by the Parliament. Earlier, if you compare with our pre-colonial era, pre-independent era or during the colonial era, this power of residuary legislation was vested in Viceroy, Governor General. Now, we know that we have come to an arrangement where there is separation of power. All the legislative works to be given to the legislature. So, any residual power was given to the legislature but of the union. Right? So, Parliament can make the laws. This is an ordinary situation. Generally, ऐसा होना चाहिए. But makers of the constitution knew that there may be certain extraordinary situations when this distribution of power needs to be altered. Where this distribution of powers needs to be altered. When Parliament should be given this authority to intervene in the state list. When Parliament should be allowed to make any laws which is even the subject matter of state legislation. So what are those situations when Parliament can interfere in the state list? Now you can also find it as a dilution of the federal principle. Parliamentary legislation in state list. Technically, these were the matters where a state should have made the laws. This was arranged, this was agreed while making of the constitution. That state इस पे कानून बनाएगी, state की legislative कानून बनाएगी. But constitution itself prescribed certain situations when parliament can interfere and make the laws in the state list. So don't you think overpowering of the union, overpowering of the states by the union overpower कर रहा है states को, क्योंकि एक true federation में हर का अपना अपना domain होता है. Can you think of a situation where a state of California is governed by the law made by United States of America, Congress? नहीं, जो उनका अपना है उसमें वही बनाएंगे जो भी हो जाए. But here we have diverted away from the true federation. We call it a quasi federation. क्योंकि we have devolved the power from union to state. It was not various states coming out and sharing their powers to the union. तो पावर हाउस कौन था? हमारे यहाँ यूनियन ही था, और हमने अलग अलग पावर बांट दिया स्टेट्स को. वो कौन से सिचुएशन है? व्हाट आर दोज सिचुएशंस व्हेन पार्लियामेंट कैन इंटरफेयर इन द स्टेट लिस्ट? फर्स्ट सिचुएशन इज प्रेस्क्राइब्ड अंडर आर्टिकल 249. फर्स्ट सिचुएशन इज प्रेस्क्राइब्ड अंडर आर्टिकल 249. Once it becomes very expedient in the national interest. Firstly, once it becomes very important in the national interest, then Council of States. Council of State means Rajya Sabha. So Rajya Sabha needs to pass a resolution. Rajya Sabha क्या करेगी? एक resolution pass करेगी. Now this resolution should be passed with the majority of 2/3 present and voting. यहां पे absolute majority की requirement नहीं है, but means simply 2/3 of the present and voting. So if it is expedient in the national interest and Rajya Sabha approves that it has become the national interest and it passes a resolution to that effect, that now it is important that in the national interest Parliament should make the laws. And that resolution of Rajya Sabha should be supported by at least 2/3 of its member present and voting. So in that situation, Parliament is enabled to make the laws. तो आप इस पूरे प्रोसेस को स्टेप बाय स्टेप में देख सकते हो. फर्स्ट स्टेप says there has to be an existing national interest and this will require a resolution made by the Council of State. तो पहली बारी काउंसिल ऑफ स्टेट एक रेजोल्यूशन पास करेगी कि हाँ जी अब पार्लियामेंट लॉ बनाएगी स्टेट लिस्ट में. देन पार्लियामेंट्स पावर विल गेट एक्टिवेटेड. तब आएगा क्या? स्टेप 2. सो स्टेप 2 व्हाट हैपेंस? पार्लियामेंट विल मेक द लॉ. What is included in the parliament? It will follow the same process. First house, second house goes to the president by an ordinary legislative process. Before starting this process is mandatory. Without passing of this resolution, parliament cannot make law in the state list. Right? So firstly, in order to make laws, parliament will need this resolution. And once this resolution has been passed, parliament can make the laws. जो उसका ऑर्डिनरी प्रोसेस होता है, दोनों हाउस से पास करके प्रेसिडेंट के साइन करने के बाद पार्लियामेंट कैन मेक द लॉ इन द स्टेट लिस्ट. Now what is the validity of this resolution which has been passed by the Rajya Sabha? This is not unlimited. So this resolution itself should be valid for 1 year. This resolution itself should be valid for 1 year. It can be further extended by 1 year. Right? So let's take an example that आज हमारा डेट है 15th of June 2023. Now on this date, Rajya Sabha passed the resolution that it is important in the national interest. Right? Now on 17th of June 2023, पार्लियामेंट इनैक्टेड वन लॉ, नेशनल इंटरेस्ट है, जल्दी कर लेंगे। तो पार्लियामेंट इनैक्टेड द लॉ ऑन 17th of June 2023. This resolution is valid till 14th of June 2023. ठीक है, 14th of June 2023 this resolution got expired. एक साल के लिए था, एक्सपायर हो जाएगा एक साल के बाद। Now the law which was made on the 17th of June, what is the validity of this law? ये लॉ कब तक वैलिड रहेगा? 6 months. 6 months from the date when this resolution has expired. यानी मैक्सिमम 1.5 साल के पीरियड तक वो रहेगा। So this law itself will cease to have effect because see, purpose क्या था? What was the purpose of enacting this law? Ideally, it is a matter which is given under the state list. In the national interest, you are enacting by the parliament. This national interest cannot be forever. Two things are there: expedient, the emergency situation, and in the national interest. Both the situation cannot be more than 2, 3, 4 साल 5, जिंदगी भर थोड़ा ना रहेगा, फिर कॉन्स्टिट्यूशन बदलना पड़ जाएगा। You require an amendment. स्टेट लिस्ट से उठा के कॉन्ग्रेंट लिस्ट में डाल दो। But this is an extraordinary situation which cannot be perpetuated. This is for this purpose there is a limitation which has been put upon this law, that this law itself will expire after 6 months from the date when resolution itself will have ceased to be in effect. This resolution can be extended by 1 year. मान लो 14 जून को एक्सपायर होने वाला था, हमने नहीं किया, then it will expire on 14th June 2025. एक साल हमने एक्सटेंड कर दिया तो द वैलिडिटी वाज 1 year. 15 जून से 2023 से 15 जून 2024 होने वाला था. बिफोर दैट वी एक्सटेंडेड बाय 1 more year. द रेजोल्यूशन इज वैलिड टिल 15th June 2025. Then the validity of law will be increased again 6 months from here. ठीक है, क्लियर है? द रेजोल्यूशन जिस दिन एक्सपायर होगा उससे 6 महीने तक ये लॉ वैलिड रहेगा. The resolution is valid for 1 year. It can be further extended by 1 year. Right? So this is the one situation wherein Parliament can make law in the state list that is prescribed by Article 249. Then Article 250. Article 250 says in the case of national emergency, Article 250, in case of national emergency, if President of India declares national emergency, emergency लगाई जा सकती है देश में. So if there is a national emergency which is declared by the President of India, in that situation, Parliament gets this power to make law in any of the state list. Because see, emergency is conceived to be one such situation where the whole federal structure becomes unitary. Whole division of power, be it administrative, be it financial, or be it legislative, can be suspended. That ideally, अगर आपको फेडरल स्ट्रक्चर से यूनिटरी बनाना है इस देश को, तो आप कैसे बनाओगे? अमेंडमेंट करके कॉन्स्टिट्यूशन में. But emergency is one such provision which prescribes for making the constitution from federal to unitary even without amendment. सारा पावर किसके पास आ गया? सेंटर के पास आ गया. हमने कोई अमेंडमेंट किया? नहीं. Simply in certain situations president declares emergency. What are the grounds for emergency? We will discuss. But if an emergency is already declared by the President of India, then Parliament gets this power to enact in any of the matters which is given under the state list. Right? And what will be the validity of those law which is made by the Parliament? 6 months. Again 6 months. 6 months from the date when emergency expires. Now let's take an example also, that today on 15th of June 2023, the emergency was declared by the President of India, and emergency continued till 15th of November 2023. Now Parliament has made the law on 16th of June 2023. So on this date, emergency expires. Emergency ceases to have effect. So the law which was made by the Parliament here will also elapse after 6 months from the date of expiration of emergency. Emergency can be extended. Emergency can be extended by one point of time. 6 महीने बढ़ा सकते हो आप इमरजेंसी को, फिर 6 महीने के बाद जरूरत पड़े, यू कैन फर्दर एक्सटेंड 6 मंथ. 6 महीने बढ़ती जाएगी. द डेट व्हेन इमरजेंसी सीज टू हैव इफेक्ट. अब मान लो कि आपका कहना है कि इमरजेंसी विच वाज डिक्लेयर्ड ऑन 15th ऑफ जून, वुड वैलिडिटी कितनी होती है इमरजेंसी की? 6 मंथ्स. So it will expire on 15th of December 2023. But on 14th of December 2023, it was extended by 6 more months. Then on 14th of June 2024, it was further extended by 6 more months. Emergency lapse तो नहीं कर रहा ना. Emergency is continuing. हमारे देश में 2 साल चला था emergency. So if emergency is continuing, the law will also have a continued effect. Law will cease to be in effect on the 6th month after the emergency has elapsed. जिस दिन इमरजेंसी खत्म होगा उससे 6 महीने के बाद लॉ खुद ही खत्म हो जाएगा, या फिर उससे पहले पार्लियामेंट ने उस लॉ को रिपील कर दिया. दैट इज द पावर ऑफ पार्लियामेंट. इवन बिफोर द एक्सपायरेशन ऑफ इमरजेंसी, पार्लियामेंट कैन रिपील द लॉ. So that is an action of the parliament. That is the choice of the parliament. Here it is talking about the automatic termination of the law. 6 महीने तक वो मैक्सिमम वैलिड रहेगा. उससे इमरजेंसी खत्म होने के 6 महीने तक. आज इमरजेंसी खत्म हुई तो आज से 6 महीने तक लॉ वैलिड रह सकता है मैक्सिमम. उससे पहले पार्लियामेंट चाहे तो उसको वेव ऑफ कर सकता है, रिपील कर सकता है, बट 6 महीने के बाद वो ऑटोमेटिकली इफेक्ट से बाहर हो जाएगा. नहीं क्लियर हो? देखो, इमरजेंसी लगाई आज ऑन 15th ऑफ जून 2023 को इमरजेंसी लगा दी. ठीक है. इमरजेंसी कैन बी इम्पोज्ड इन आवर कंट्री फॉर ए पीरियड ऑफ 6 मंथ्स. एक बारी में 6 महीने लगा सकते हो. सवाल ये उसको बढ़ा सकते हैं कि नहीं? बढ़ा सकते हैं. फिर से 6 महीने के लिए, फिर जरूरत पड़ी अगेन 6 मंथ, अगेन नीडेड 6 मंथ, राइट. सो ऐसा करके आप बढ़ा सकते हो. मान लो इमरजेंसी 2 साल तक चला. 15th of June 2023 is the date when emergency ceased to have effect. इमरजेंसी खत्म हो गया. अब इस बीच में पार्लियामेंट ने कोई लॉ बनाया था स्टेट लिस्ट में. अगर पार्लियामेंट ने यूनियन लिस्ट में लॉ बनाया तो उसको खत्म ही क्यों करना? वो तो उसका अपना पावर है. मैटर उस बात पे, डिबेट उस बात पे चल रही है कि पार्लियामेंट ने स्टेट लिस्ट में लॉ बना दिया था, विच इज नॉट द ऑर्डिनरी पावर ऑफ द पार्लियामेंट. अगर इमरजेंसी के पहले या इमरजेंसी के दौरान या इमरजेंसी के बाद ए पार्लियामेंट इज मेकिंग लॉ ऑन एनी मैटर्स विच इज गिवन अंडर द यूनियन लिस्ट, उसको कैंसिल करने की जरूरत ही क्यों है? वो क्यों होगा कैंसिल? वो नहीं होगा. खत्म कौन होगा? इफ पार्लियामेंट इज मेड एनी लॉ विच इज देयर इन द स्टेट लिस्ट. So now if parliament in the meanwhile has enacted on any matters which is given under the state list and emergency is ceased to have effect on the 15th of June, so maximum for 6 months period this law can be effective. उसके बाद नहीं हो सकता. वो उससे पहले खत्म किया जा सकता है. by parliament repeals that, it can be revoked, but it will automatically end after 6 months. It cannot be extended beyond 6 months. What? The law which was made during the emergency in the state list. ठीक है? Right? So this is another occasion when parliament can make the law in the state list. There is a third occasion. If 2 or more states request the parliament. This is second. First one was Article 249. What we are talking about when Parliament can make the law in the state list. First we see under Article 249, राज्य सभा की resolution पास करेगी. Second we saw emergency के टाइम पे. Third is अगर 2 स्टेट बोलते हैं कि भाई मेरे से लॉ नहीं बन रहा, बना दो, So Parliament can make the law. So with consent of two or more states, Parliament will make the law. अब Parliament will make the law in the state list for these two states. Suppose Maharashtra and Karnataka says, please make a law on police. We are not able to make the law on the police. हमसे नहीं बन पा रहा. So Parliament, upon their request, can accept that request and make the law on that. And these law will be valid only on these two states, Karnataka and Maharashtra. अब इसका तरीका क्या है? State request कैसे करेगी? The legislature of the state should pass a resolution requesting Parliament to make the law on any matter specified in the state list for that state. तो महाराष्ट्र और कर्नाटका की स्टेट की लेजिस्लेचर ने एक रिक्वेस्ट पास किया पार्लियामेंट से टू मेक लॉ इन द स्टेट लिस्ट. अब नाउ टुमारो Gujarat also wants that same law should be applied to me. So it can be extended, provided the legislature of Gujarat also passes a resolution. So this is the third situation that Parliament can make the law in the state list. And any law which is made in the state list by the Parliament on the request of the state can only be repealed by the Parliament, can only be amended by the Parliament. ऐसा नहीं हो सकता कि पार्लियामेंट ने लॉ बना के दे दिया, स्टेट उसको अपनी मर्जी से चेंज करते रहे. दिस इज नॉट पॉसिबल. सो एनी लॉ विच इज मेड इन द स्टेट लिस्ट बाय द कंसेंट ऑफ द टू और मोर स्टेट्स कैन ओनली बी रिपील्ड और अमेंडेड बाय द पार्लियामेंट इटसेल्फ. स्टेट रिक्वेस्ट कर सकती है, भाई अपना लॉ रिपील कर लो, मेरा काम हो गया. बट एनी लॉज मस्ट बी रिपील्ड ओनली बाय द पार्लियामेंट. स्टेट लेजिस्लेचर डू नॉट हैव द कैपेसिटी टू अमेंड और रिपील एनी लॉ विच इज मेड बाय द पार्लियामेंट. So this is third situation when Parliament can. अब एक स्टेट करेगी तो यहाँ पे पॉलिटिकल लिंक्स ज्यादा हो जाएंगे. सपोज दैट इज वन वे ऑफ सबवर्टिंग द फेडरेशन. अगर मान लीजिए बीजेपी है, बीजेपी की यूनियन में सरकार है, एक स्टेट में बीजेपी की सरकार होगी तो वो अपनी सारी पावर ही दे देंगे यूनियन को. So it may have the another political vendetta. If two states are requesting, this means there is certain problem. Two or more, इसलिए क्या है, two or more, minimum तो two होना ही चाहिए. So at least two, दो का कंसेंट तो हो. जब तक रिपील नहीं किया जाएगा तब तक आप लोग. दिस इज अ परमानेंट लॉ बिकॉज इट हैज बीन मेड बाय द कंसेंट ऑफ द स्टेट. बाकी जगह स्टेट की कंसेंट नहीं थी. दैट वाज अ सिचुएशनल थिंग. इमरजेंसी हो जाएगा, इमरजेंसी परमानेंट नहीं रहेगा ना. नेशनल इंटरेस्ट रहेगा, वो भी तो परमानेंट नहीं रहेगा ना. बट कंसेंट ऑफ द स्टेट तो परमानेंट है. आपने एक बार कंसेंट दे दिया तो दे दिया, भुगतो अब. ठीक है. दिस इज थर्ड सिचुएशन. नाउ देयर इज अ फोर्थ सिचुएशन. आप बहुत सारे ट्रीटी और कन्वेंशन के बारे में पढ़ते होंगे. रामसर कन्वेंशन है, दैट इज फॉर वेटलैंड्स, एनवायरमेंट में पढ़ना है. सो इफ इंडिया साइंस टुमारो अ कन्वेंशन इन फॉरेन कंट्री and that convention has a limitation. आपने पेरिस क्लाइमेट एग्रीमेंट के बारे में सुना होगा. That under the Paris climate agreement, every country has to reduce their carbon emission by certain percentage. So India is also signatory to it. So in order to reduce that carbon emission, India will need to make certain laws, to take certain measures domestically. Now there are various issues. Wetlands are the subject matter of state. तो उसमें पार्लियामेंट को इनैक्ट करना पड़ेगा, बट दैट इज ऑलरेडी द पार्ट ऑफ स्टेट लिस्ट. पार्लियामेंट के पास दो रास्ते हैं. वन, इधर इट कुड डायरेक्टली इनैक्ट, और सेकेंडली इट कुड रिक्वेस्ट ऑल द स्टेट. पॉलिटिकल डिफरेंसेस की वजह से सारे स्टेट बात मानेंगे नहीं. सो कॉन्स्टिट्यूशन इटसेल्फ प्रेस्क्राइब अंडर आर्टिकल 253 देयर इज अ प्रोविजन दैट इन ऑर्डर टू इंप्लीमेंट एनी इंटरनेशनल ट्रीटी, कन्वेंशंस और एग्रीमेंट्स, if it is required to enact in the state list, Parliament will be empowered to enact in the state list. चाय पीना किसी को? आप लोग पी के आए होगे, मैं नहीं पिया, मैं पी लेता, ठंडा हो गया. right? So in order to implement any agreement, treaty, conventions, Parliament gets this power to enact even on the matters which is given under the state list, right? So this is the distribution of legislative powers and deviances from the ordinary setup. Legislative power में आपको तीन चीजें ध्यान रखनी है, 3 lists, right? Secondly, Parliament's intervention in the state list, ये इंपॉर्टेंट हो जाता है. अगर मीन्स में स्टैटिक नेचर का क्वेश्चन आएगा, लेजिस्लेटिव रिलेशनशिप पे आएगा, तो ये जरूर पूछेंगे, व्हेन कैन पार्लियामेंट इनैक्ट इन द स्टेट लिस्ट. दे मे पुट इन ए डिफरेंट वर्ड. इज द डिवीजन ऑफ 3 लिस्ट sacrosanct in India? Can it be altered? If yes, what are the constitutional provisions regarding it? मैंने उसी चीज को अलग तरीके से कह दिया. What are the occasions when Parliament can enact in the state list? Explain in the light of legislative relationship. इसमें बेसिक्स आपको लिखने हैं लेजिस्लेटिव रिलेशनशिप के, एंड ये प्रोविजंस लिखने हैं जब पार्लियामेंट स्टेट लिस्ट में कानून बना सकती है. तो लेजिस्लेटिव रिलेशनशिप में इतना कवर्ड है. नाउ वंस द यूनियन और स्टेट हैज मेड द लॉ, अब बारी आती है उस लॉ को इंप्लीमेंट करने की, राइट? अब यहां पे पता चलता है कि स्टेट्स के इंडिया में कोई पावर नहीं. All the executive powers of the states are made subordinate to the executive power of union. वो कैसे और क्यों, ये देखते हैं. So administrative relationship will cover that who will have the executive power on which kind of law. If Parliament has enacted any law, who is going to implement that? If state legislature has enacted the law, who is going to implement that? And if in concurrent list both legislature can enact, then कौन करेगा उसको implement? ठीक है. First one is if any law which has been made under the union list, administrative relationship पे, upon the distribution of administrative relationship, there is no specific question I have seen in UPSC. हाँ, किसी स्पेशल पार्ट, UPSC I am talking about GS, तो किसी स्पेशल ओकेजन पे, लाइक वर्किंग ऑफ सीबीआई, अलॉटमेंट ऑफ और एलोकेशन ऑफ सेंट्रल फोर्सेस इन स्टेट, सीआरपीएफ लगा दिया, बीएसएफ लगा दिया, आपस्पा का डिस्प्यूट हो गया, रोल ऑफ गवर्नर को लेके, देयर आर वेरियस क्वेश्चंस इन आस्क्ड इन द जीएस. तो दीज आर इशू स्पेसिफिक क्वेश्चन इंस्पायर्ड फ्रॉम द करंट अफेयर्स. बट एज ए स्टैटिक की व्हाट इज द डिस्ट्रीब्यूशन ऑफ एडमिनिस्ट्रेटिव रिलेशनशिप or what is the alteration in it, it has not been asked in the general studies paper, but it has been asked in the optional paper. So उस point of view से, because now they are asking the optional question in GS, तो हमें ये इस point of view से भी cover करना चाहिए, right? So first one is, if any law which is made under the union list, the power to implement this administrative power lies with the union executive. पढ़ा था आपने, all the executive power of union shall be vested in president. The executive power of union क्या है? All the laws which has been enacted by the parliament under the union list. So if any law which has been enacted by the parliament under the union list, the power to implement those laws lies with the president of India, and he shall implement those laws directly or through officers subordinate to him, right? Secondly, if any law which is made by the state legislature in the state list, the power to implement lies with the state executive. यहां तक तो सिंपल है. Now, if any law which is made in the concurrent list में कोई लॉ बना हुआ है, the power to implement those laws किसके पास होता है? अब देखो, if there is a conflict between legislative powers, the priority is given to whom? Parliament. But in this scenario, even if a law in the concurrent list is made by the parliament, by default the executive power lies with the states. Concurrent list में अगर कोई लॉ चाहे पार्लियामेंट ने भी बनाया हो, by default it will be with the state. However, if while making the law, Parliament says that no, executive power to implement this law will lie with the union, then only it will be with the union. देखिए, suppose that there is a subject matter called XYZ. It is mentioned in the concurrent list. Parliament can also make the law, or a state can also make the law. If a state makes the law, it is but obvious the executive power will be with the state. But if Parliament makes the laws, it will also be with the states. Except while making the law, Parliament itself declared that no, even though the law is in concurrent list, the executive power will lie with the union. अगर लॉ में एक्सप्रेसली नहीं मेंशन्ड है कि इसको इंप्लीमेंट करने का पावर यूनियन के पास है, तो बाय डिफॉल्ट किसके पास चला जाता है? स्टेट के पास चला जाता है. ठीक है. तो दिस इज द ऑर्डिनरी डिस्ट्रीब्यूशन ऑफ एडमिनिस्ट्रेटिव पावर्स बिटवीन यूनियन एंड स्टेट्स. बट यहां पे दो चीजें आती हैं. आर्टिकल 257 and Article 256. There are two articles. Article 256 and Article 257. Article 256 क्या बोलता है? All these executive powers of the state, whatever executive powers of the state, states shall exercise those power in such a manner it is not prejudicing the powers of the union. स्टेट के पास जो भी एग्जीक्यूटिव पावर है, चाहे कॉन्करेंट लिस्ट से आई हो, चाहे स्टेट लिस्ट से आई हो, चाहे यूनियन लिस्ट से आई हो, चाहे प्रेसिडेंट ने ट्रांसफर कर दी हो, चाहे पार्लियामेंट ने ट्रांसफर कर दी हो, देयर कैन बी म्यूचुअल ट्रांसफर ऑफ एग्जीक्यूटिव पावर्स ऑल्सो. ये कैसे होता है? एक मिनट. सपोज दैट अंडर यूनियन लिस्ट द एग्जीक्यूटिव पावर वाज विद द यूनियन. नाउ इफ प्रेसिडेंट वांट टू ट्रांसफर दिस पावर फ्रॉम यूनियन टू स्टेट, मतलब प्रेसिडेंट ने कानून बनाया एनडीपीएस, और एनडीपीएस एक्ट में द पावर लाइड विद द यूनियन, बट प्रेसिडेंट वांट्स दिस टू ट्रांसफर टू द लोकल पुलिस ऑफ द स्टेट. प्रेसिडेंट विद द प्रायर कंसेंट ऑफ द स्टेट गवर्नमेंट ट्रांसफर दिस पावर. आपने एक और चीज ध्यान में देखा होगा, प्रेसिडेंट कैन डायरेक्टली डिस्चार्ज हिज ड्यूटीज और थ्रू ऑफिसर्स सबऑर्डिनेट टू हिम, एंड सेकेंडली ही हैज द पावर टू मेक रूल्स फॉर द एलोकेशन ऑफ बिजनेसेस. सो यूनियन गवर्नमेंट का ये बिजनेस with the prior consent of the state government, president can transfer. Secondly, while making the law itself, even in the union list, parliament can transfer the executive power. मनरेगा हमने बना दिया, implement कौन करेगी? States. So this delegation of powers is possible mutually. स्टेट वाले भी अपनी पावर्स यूनियन को दे सकते हैं, but the previous consent जरूरी है, right? So whatever the powers state has got, whatever the executive powers of the state is, the state should exercise in such a manner it is not compromising with this executive powers of the union. मतलब चीफ मिनिस्टर की पावर उस हद तक लिमिट रहेगी जब प्राइम मिनिस्टर की पावर को कॉम्प्रोमाइज नहीं होता है. स्टेट के जो सेक्रेटरीज हैं उसकी पावर उस हद तक रहेगी, यूनियन के सेक्रेटरीज की पावर कॉम्प्रोमाइज नहीं होती है. So in a nutshell, can you see the subordination of executive powers of the states by the hands of union? Article 256 expressly mentions that. But इसका मतलब ये नहीं कि state government is under the control of union government. ऐसा नहीं मानना है. It's simply कि अब दो आदमी पावर एक्सरसाइज करेंगे. मुझे भी फ्रीडम ऑफ मूवमेंट है, आपके पास भी फ्रीडम ऑफ मूवमेंट है. मुझे भी फ्रीडम ऑफ लिबर्टी आपके पास भी है. अब 50 लोगों के भीड़ में बोलो मुझे बॉक्सिंग करना है, तो ये बात ऐसी नहीं कि आप हमारे कंट्रोल में हो तो मैं बॉक्सिंग कर सकता हूं. इट इज सिंपली दैट योर पावर शुड बी एक्सरसाइज इन सच ए मैनर दैट माई पावर्स आर नॉट jeopardized. There is no threat to my power. So you should stop yourself there itself. But there is no limitation put upon the powers of parliament. Indeed, there is certain additional truth which is given to the union. Union can give directions to the state. कुछ अपनी बातें मनवा सकता है, और अगर यूनियन की कही बातें स्टेट नहीं मानता है तो उसके लिए पेनल्टी भी लगा सकता है, एंड दैट पेनल्टी इज वेरी सीवियर. पैसे वाली पेनल्टी नहीं है, प्रेसिडेंट रूल लगा सकता है. So firstly, you should note that Article 256 says the executive powers of the state should be exercised in such a way that it does not prejudice the executive powers of the union. And secondly, 257 says यूनियन कैन गिव डायरेक्शंस फॉर सर्टेन मैटर्स। यूनियन गवर्नमेंट स्टेट्स को कुछ डायरेक्शंस दे सकती है कुछ चीजों के लिए। एंड व्हाट आर दोज डायरेक्शन, ऑन व्हाट ग्राउंड्स, फॉर व्हाट पर्पसेस यूनियन कैन गिव द डायरेक्शंस। फर्स्ट इज फॉर कंस्ट्रक्शन एंड मेंटेनेंस ऑफ मीन्स ऑफ कम्युनिकेशन फॉर नेशनल एंड मिलिट्री पर्पस। सो आर्टिकल 257 में क्या दिया जा सकता है, कैसे डायरेक्शंस, फॉर मीन्स ऑफ कम्युनिकेशन फॉर नेशनल और मिलिट्री पर्पस। सेकेंडली, फॉर मेंटेनेंस एंड प्रोटेक्शन ऑफ रेलवेज। अब रेलवे किसके डोमेन में आता है, यूनियन के डोमेन में आता है। बट इन ऑर्डर टू बिल्ड द रेलवे नेटवर्क, अब खाली दिल्ली में रेलवे बनाओगे, बोले कि मेरे यहाँ रेलवे आ गया है, द रेलवे लाइन्स विल गो थ्रू द स्टेट्स। अब यूनियन की सरकार किस किस स्टेट तक, किस किस कोने तक जाके उसको प्रोटेक्ट कर पाएगी? दिस इज क्वाइट अनरीजनेबल। So constitution casts this obligation that union will give you certain direction to the state and the state will take all the necessary steps for the protection and security of railway, because railway is a national property। रेलवे है आपकी संपत्ति, तो बेडशीट ले आइए घर। ऐसा करना है? नहीं करना है। वंदे भारत शुरू हुआ तो नल पहुंच गया लोगों घर, वहां से निकल के सारी घूमने वाले सीट का घुमा दिया। So this is second situation when union can give the direction to the states. And third situation is that union can also give direction to the states for promotion of education in mother tongue for those children who are belonging to linguistic minorities। किसी भी स्टेट में अगर linguistic minorities के बच्चे हैं, उनको अपने मदर टंग में एजुकेशन लेना है, उसके लिए union can give the mandatory instructions। So three situations are there: communication, railways, and promotion of mother tongue, promotion of education in mother tongue। Now these are the directions which are mandatory, states will be bound to follow this। Now if states does not bound to follow, उसका इलाज कहां दिया हुआ है? आर्टिकल 365 में, राइट। सो इफ व्हाट 365 says that if states is not following any of the mandatory directions which is given by the union, it will be assumed that constitutional machinery has to fail in that state। That will be counted as failure of constitutional machinery in the state। और जब भी ऐसा होता है तो क्या होता है? प्रेसिडेंट रूल लगाया जा सकता है, राइट। अब ये ऑर्डिनरी सिचुएशन है जहां पे यूनियन कैन गिव डायरेक्शन ऑन 3 ग्राउंड्स टू द स्टेट्स। बट ऑन एक्स्ट्रा ऑर्डिनरी सिचुएशंस, जब कोविड आया था उसके बाद यूपीएससी ने एक इसी पे बेस्ड क्वेश्चन पूछा था। तो देयर इज वन पर्टिकुलर एक्ट, एसेंशियल कमोडिटीज एक्ट, that says storage of any commodity beyond a particular limit is a offense। जैसे नमक की कालाबाजारी आपने शुरू कर दी, पता चला अगले दिन 90 रुपए का नमक आ जाएगा। पता नहीं किसी ने अफवाह करें, मेरे पापा एक बोरी लेके आ गए नमक की, सच में लेके आ गए, और कुछ नहीं, अगले दिन भी 10 रुपए 15 रुपए का मिल रहा है। मैंने कहा आप बेचो, कहां बेचोगे? So this, अब ड्यूरिंग द टाइम ऑफ कोविड देयर वर सर्टेन आइटम्स व्हिच वर इंक्लूडेड एज अ पार्ट ऑफ एसेंशियल कमोडिटी, एंड अपॉन दिस, इन अंडर द एसेंशियल कमोडिटीज एक्ट, यूनियन गवर्नमेंट हैज द पावर टू सेट द लिमिट्स। स्टेट कैन आल्सो सेट द लिमिट्स, बट यूनियन गवर्नमेंट आल्सो हैज द पावर, एंड यूनियन हैज द पावर टू गिव डायरेक्शन टू द स्टेट फॉर सिक्योरिंग दोज लिमिट्स, दैट नोबडी इज स्टोरिंग बियॉन्ड दैट, नोबडी इज होर्डिंग फूड ऑन दैट। और यूपीएससी ने यही सवाल पूछ दिया, क्योंकि ये कोरोना का था तो थोड़ा कॉन्टेम्पररी था, that what are the powers through which union can give direction to the states examined in the light of essential commodities act। ऐसा ही कुछ क्वेश्चन पूछा, राइट। सो दे कैन गिव, दिस इज द ऑर्डिनरी सिचुएशन। बट यही जब इमरजेंसी आ जाता है तो द होल power, administrative power of the union becomes subject to the the state becomes subject to the union। The power of giving directions is not only limited to these three things, Union can give direction to the state on any matters when there is an emergency in it. Right? So these are the administrative powers, division of administrative powers between union and states. Now you will find there are certain conflict areas. There are certain conflict areas. अब इस administrative power के अंदर there are certain tension areas between union and state. One is abuse of Article 356. Article 356, under Article 356, President rule can be imposed due to the failure of constitutional machinery. एक तो हमने देखा failure of direction, failure of following of direction by the states, the direction which is given by the union, that will be taken as failure of constitutional machinery. President can impose the president rule. Also, while we were discussing about the role of governor, you would have remembered that governor sends a report to the Ministry of Home Affairs. Governor एक report भेजता है. In that report, governor can recommend the imposition of the president rule. And this power of governor has been widely criticized because based upon that recommendation, president to impose कर सकते हैं president rule. But how governor is satisfied that constitutional machinery has failed? So his satisfaction is always subjected to criticism. It is argued that he is getting satisfied quite easily on the basis of party guidelines. Discretionary power. Because he can recommend. While recommending for the dissolution of Council of Ministers in the state, governor does not need the permission or advice of the Council of Ministers itself. So he can recommend. Now, without giving them any party an adequate opportunity to form the government, still he is recommending that government cannot be formed here. So what he is doing? He is recommending for the president rule. Right? So this is one area which has been a bone of contention, that is abuse of Article 356. Now second situation, second conflict area is management of all India services. Management of all India services. All India services may include IAS, IPS, etc. So these are the personnel who are appointed by the union, but they are working in and for the state government. But their final appointment and dismissal, reduction in the ranks, all things are depending upon the union government. State government can only work, state government is only responsible for their transfer, posting, promotions, etc. Appointments. They can give them certain duty, they can take certain duties from themselves. Now also, suppose that if any officer was given a very important duty, but they being the part of all India services can be called into the deputation by the central government. Central government उसको वापस बुला लेगी, आ जाओ भाई तुम हमारे बंदे हो. And secondly, appointment of the officers into the administration of the state, this is also being considered as the violation of federal principles. So this is another area of concern. Now third area is role of central forces and their powers. You know, there are various border guarding forces. There are various bordering states. कुछ समंदर पे हैं, कुछ हमारे बाकी पड़ोसी मुल्क के साथ हैं. There are certain states which are called landlocked. Landlocked का क्या मतलब होता है? जिनका कोई ओपनिंग नहीं है. MP सब तरफ से जमीन से घिरा हुआ है, बाकी स्टेट्स हैं. लैंडलॉक कौन नहीं होते हैं? या तो जिनका ओशन में एक्सेस हो या फिर किसी और कंट्री के साथ. लैंडलॉक कंट्रीज भी होते हैं. लैंडलॉक कंट्रीज मीन दे डू नॉट हैव द एक्सेस टू ओशन. राइट? तो they suppose that there are border guarding forces, like example take BSF, border security force, and this happened during the elections of West Bengal. अब सोच लो BSF है, this is guarding India's border with Pakistan and then Pakistan, East Pakistan, Bangladesh. तो दोनों पे हमने बीएसएफ को लगा के रखा है। वन फोर्स वन बॉर्डर का कॉन्सेप्ट है, एक फोर्स को एक बॉर्डर दिया हुआ है। इंडिया नेपाल गार्ड करने के लिए एसएसबी, यू वुड हैव हर्ड अबाउट सशस्त्र सीमा बल, है ना। एंड देन यू हैव इंडिया चाइना गार्ड करने के लिए आईटीबीपी, हेली ट्रेन टेरेन पे। आफ्टर 1965 वॉर वी फेल्ड दिस नीड दैट वी डू नॉट हैव एनी स्पेशलाइज्ड फोर्स विच आर एक्सपर्ट इन द माउंटेन फाइटिंग, माउंटेन वॉरफेयर, तब उनको हिमवीर बोलते हैं आईटीबीपी को, इंडो तिब्बतन बॉर्डर पुलिस। आर्मी हमेशा नहीं रहती बॉर्डर पे, आर्मी विल ओनली टेक द चार्ज ड्यूरिंग द केस ऑफ वॉर, अदरवाइज वो बर्न आउट हो जाएंगे, जब लड़ाई होगी तो बेचारे का पसीना निकल जाए, इसलिए उनको पीस पे रखे रहते हैं, पीस भीतर में। वंस द वॉर स्टार्ट दिस बॉर्डर सिक्योरिटी फोर्सेस विथड्रॉज एंड आर्मी टेक्स ओवर। Now this border security force, for example BSF, it is working under the Ministry of Home Affairs of Union. They are the paramilitary, they are not the military. आपका जो GS पेपर 3 है ना, उसमें इंटरनल सिक्योरिटी है एक सब्जेक्ट, इन दैट यू विल फाइंड वन टॉपिक वेरियस सिक्योरिटी एजेंसीज एंड देयर मैंडेट, तो उसमें आपको ये सारे पढ़ने होंगे, ऑल द CRPF, देन यू विल आल्सो रीड अबाउट NIA जो भी नए नए हैं, ED, then you will also read about ED, थोड़ा अभी पॉपुलर हो गया हुआ है ना, and money laundering itself is a part of your internal security, specifically mentioned है. So now this is the paramilitary force, this is working under the command of the union, but this is stationed in suppose West Bengal Bangladesh border, East Bengal West Bengal. अब who can increase, this is working under the act of, there is a BSF act जिसके अंदर इसको क्रिएट किया गया, BSF एक्ट के अंदर इसको क्रिएट किया गया। So their powers are getting derived from that act. Who has this is an act made by the parliament. Who has the executive power? Union government. Who can amend or repeal the act is the parliament. So suppose ये वेस्ट बंगाल है और ये इधर बांग्लादेश है और इधर वेस्ट बंगाल है, तो हमने क्या किया, BSF को इस टेरिटरी की प्रोटेक्शन के लिए हमने स्टेशन कर दिया, बोला विद इन 5 किलोमीटर ऑफ दिस बॉर्डर एनी सर्च सीजर हैज टू बी डन, BSF कैन डू दैट। सर्च सीजर अरेस्ट इन सब करने की पावर किसकी होती है, लोकल पुलिस की। इवन आर्मी पर्सनल इज कमिंग, दे डू नॉट हैव द पावर विच इज एक्सरसाइज्ड बाय द लोकल पुलिस अथॉरिटी। उनका अपने कैंटोनमेंट में हो सकता है, अपने एरियाज में हो सकता है, बट लोकल एरियाज में पुलिस की पावर होती है। BSF, पैरामिलिट्री, इन सब की पावर हमारे ऐसे दिल्ली में किसी को सर्च सीजर नहीं कर सकते वो। So this is, if it has to be done, this has to be done by the Delhi police. So similarly in West Bengal, any search, seizure, arrest has to be done, it has to be done by the state police. But since it is a bordering areas, BSF is also given the power कि आप 5 किलोमीटर तक ऐसे कर सकते हैं from the border, within the border. Because someone is say smuggling, someone is trying to intrude into India, कुछ घुसपैठ हो रहा है, तो उसको प्रोटेक्ट करना इन्हीं की जिम्मेवारी है। They would be needing certain powers. Now tomorrow parliament say okay 25 किलोमीटर, 25 किलोमीटर में पूरा एक जिला कवर हो जाता है। What will the district police do? And during West Bengal election, this power of BSF was unilaterally increased by the union. So this will create a conflict between the local police and the central police. Now what is then the rationale of creating the central police? Why not everything is left to the state police? See, in forces को, paramilitary को एक और नाम से जाना जाता है, CAPF, Central Auxiliary Police Forces. Auxiliary means they will be supporting the normal police whenever the things will get out of their control. इस बार क्वेश्चन पूछा था, it is the duty of the union to protect the state from internal disturbance or external aggression. It is the duty of the union, that is a correct statement. So how union is going to protect if they do not have the forces? So union maintains these kinds of forces. These are the specialized forces. For that matter, you will see CISF. आप मेट्रो से ट्रैवल करते हो, तो for that union has a specialized force, CISF, Central Industrial Security Force, to safeguard the various industrial establishment, metro being one of them. सो अगर स्टेट को अपनी इंडस्ट्रियल एस्टेब्लिशमेंट करती है, सीआरपीएफ को पे करो, ले जाओ स्टाफ। जैसे आप सुनते होंगे नीता अंबानी, मुकेश अंबानी को Z+ सिक्योरिटी मिली है। देयर आर वेरियस काइंड्स ऑफ Z+ सिक्योरिटी। द मोस्ट protected is the Z+ security which is maintained by SPG, Special Protection Group, which has been created for President and Prime Minister and former Prime Minister. सोनिया जी को नहीं मिलता, प्राइम मिनिस्टर नहीं बने। वहां पे अलग अलग फोर्सेस से हम रिक्रूट करते हैं। देन यू विल हैव द Z+ सिक्योरिटी ऑफ CAPF, CISF, फिर करके दिल्ली पुलिस की भी Z+ सिक्योरिटी होती है, उतनी एफिशिएंट नहीं है। Z+ मीन्स देयर विल बी वेरियस लेयर्स, सर्कल में। सो अंदर में सबसे हम तैनात वाले कमांडो होंगे, फिर आउटर लेयर पे स्टेट पुलिस होगी, ऐसे बहुत सारे लेयर होते हैं, तो उसको बोलते हैं Z है, Z+ है, Y है कैटेगरी ऑफ सिक्योरिटी। तो दीज फोर्सेस हैव देयर सर्टेन मैंडेट। तो ऐसा नहीं कि इन फोर्सेस को बंद कर दे। व्हाट इज कॉजिंग द कॉन्फ्लिक्ट इज अ यूनिलैटरल इंक्रीज और डिक्रीज ऑफ द पावर्स। Decrease of the power will not cause the conflict. What will cause the conflict is increase of the power. So one of the area of contention is deployment and the role of central police forces. Another example you can take, this is not for a, you can say this thing, central forces की नहीं, but एक act है which is very controversial. APSPA Act का नाम सुना होगा आपने, आर्म्ड फोर्सेस स्पेशल पावर एक्ट, आर्म्ड फोर्सेस स्पेशल पावर एक्ट। ये ओवरलैप है हमारे पॉलिटी और इंटरनल सिक्योरिटी का, ऑल दिस टॉपिक्स। तो APSPA क्या है? एक 1958 में बनाया गया एक एक्ट है। एज द नेम सजेस्ट, इट इज एन एक्ट विच इज क्रिएटेड टू गिव स्पेशल पावर्स टू होम? आर्म्ड फोर्सेस, because these armed forces will be deployed in disturbed areas. कहां डिप्लॉय किए जाएंगे? Disturbed areas. So one term you get as disturbed areas. What are these disturbed areas and who can declare this as a disturbed area? Central government can declare any area as a disturbed area. Now with an amendment, this power has been given to the state also. So states can also declare any area as disturbed area and center can declare any area as disturbed area. Now in these disturbed areas, these forces can be stationed, and while operating in these disturbed areas, the forces will get an enhanced power what they usually have. Here in suppose in Delhi, in your Karol Bagh, a police comes and catches you. They say that you are committing certain crime. Let me search. Let me do certain seizures from you. आपका phone लेने दो. So they can do, but they can do within a particular limit of force. They cannot use unlimited force. But what APSPA has done, that they have empowered police personnel or armed forces. Armed forces means anyone, be it the police or be it the army or be it the paramilitary. Those who are operating in that area, सबके ऊपर ही लागू होगा। So armed forces has been given extraordinary power to take up search, seizure and arrest, and in order to do that they can use the force, and they can use the force even up to a limit of causing death. मतलब आप रात को कहीं जा रहे थे, आपको रोका, there is suspicion, allow me to search. Now there may be some person who is female, she is being hesitant, the policeman can use the force, they can shoot. So people activists against the APSPA, they have been alleging these kinds of extrajudicial killings. Killings is not authorized in any civilized society except as per the procedure established by law. Article 21. Now which is what? Due process of law. उसके बिना किसी को मारना crime है. Unless and until you have been given certain exemptions under IPC. Private defense, self defense, ये सब चीजें. Now these killings has been not done by the orders of the court. This is not judicial killing. So these are extrajudicial killings. Any extra such judicial killings must be subjected to the scrutiny of courts. मान लीजिए पुलिस ने किया, आपकी सेफ्टी के लिए किया, बट कोर्ट को इन्वेस्टिगेट नहीं करना चाहिए उस मैटर को. इनकाउंटर हो गया, जीप पलट गई, तो जीप सही में पलटी या पलटवा दी, इन्वेस्टिगेशन नहीं होना चाहिए. So do not court examine that. Now the problem in AFSPA that even the police personnel or the armed forces personnel who were given this power to use the force causing death, and they have been exempted from the judicial scrutiny. They cannot be called into question into court for any act done during those states and during those areas. So people raise this argument against the AFSPA that you are giving extraordinary power without being subject to judicial scrutiny. There are movements in areas, especially northeastern states, to repeal the AFSPA. But there are certain arguments which is cited in the favor of AFSPA. Like, see, these disturbed areas, the duties which need to be performed in these disturbed areas are extraordinary in nature. So it will require extraordinary powers also. Secondly, it is important for the security of the state, security of the nation. Thirdly, it is important also for the security of the security personnel. Those areas are disturbed. एक सेकंड की देरी हुई, उधर से AK-47 निकलेंगे. So in order to deal with these situations, the police personnel or armed force personnel, they were given this extraordinary powers. But every coin has a two side. तो कुछ arguments इसके favor में है, तो कुछ arguments इसके against भी है. What are the arguments against it? Misuse of the provisions and fake encounters like extrajudicial killings, etc. This has been quite reported. People say AFSPA is a license which has been given to armed forces to kill. इस हद तक allegations करते हैं. अब इसके बीच का रास्ता क्या निकाला जाए? Now see, these kinds of extrajudicial killings, and if courts are not interfering in it, it will raise a trust deficit. लोगों को भरोसा उठ जाएगा, लोगों को लगेगा ये सरकार जो है वो अत्याचार करने के लिए बनी है. So this will create an anti-government, anti-system movement, and this actually happened. There is a case, Naga People's Movement for Human Rights versus Union of India. AFSPA के ऊपर केस है. अब while hearing this case, Supreme Court has given certain guidelines. आप लिख सकते हो नागा पीपल्स. अच्छा, नॉट टू वरी, अगर जो हम डिस्कस कर रहे थे पीपल हैव मिस्ड, तो मैं टेलीग्राम में डाल दूंगा रिटन में. नॉट टू वरी, क्योंकि आई थिंक बहुत लोगों ने मिस कर दिया. नागा पीपल अ मूवमेंट फॉर ह्यूमन राइट वर्सेस यूनियन ऑफ इंडिया. दिस इज वेरी इंपॉर्टेंट केस ऑन द AFSPA. अब इसमें Supreme Court has given certain guidelines. Though the power to declare any area as disturbed area lies with the union. So union can do that. Supreme Court has agreed that this is the power which can be unilaterally exercised by the union. But जो हो सकता है जरूरी नहीं वो करे. करना क्या चाहिए? So Supreme Court has given these guidelines that before declaring any area as disturbed area, union should seek the consultation from the concerned state, because states would be more aware about the ground realities. Supreme Court also has accepted that officers can use the force, but they have directed the officers in charge to use the force which is bare minimum and which is minimum essential force. Now Supreme Court also gives these guidelines that once AFSPA has been imposed in any of the areas, आज AFSPA लगा दी, but हमेशा AFSPA लगा के छोड़ नहीं देना है. There has to be a periodic review after 6 months. So these are certain guidelines by the Supreme Court. What other committees or commissions have to say about it? Fifth, the second Administrative Reforms Commission and its fifth report, Administrative Reforms Commission itself has recommended to repeal AFSPA. They says आप AFSPA को हटा दो and bring in other more comprehensive law. ये 7 सेक्शन का एक्ट है, खाली पावर देने के लिए बनाया है. There is no protection in this act given to people, or there is no provision of judicial scrutiny. So second Administrative Reforms Commission, उसका एक fifth, sixth report है. Then you have fourth report that is on conflict resolution techniques. तो उसमें बहुत डिटेल में वो दोनों 5th 6th रिपोर्ट का आपको जरूरत पड़ता है इंटरनल सिक्योरिटी में. We will also read about the second administrative commission reforms in governance portion, e-governance, digital governance वाले में. So that is important commission जिसके recommendation आप यूं कहो कि आधी यूपीएससी के सिलेबस सेकेंड एडमिनिस्ट्रेटिव कमीशन रिफॉर्म्स है. एथिक्स का तो आधा सिलेबस उधर ही से भरा हुआ है. ठीक है. तो सेकेंड एआरसी ऑल्सो हैज रिकमेंडेड फर्स्टली इफ पॉसिबल रिपील एंड ब्रिंग इन अ मोर कॉम्प्रिहेंसिव लेजिस्लेशन. सेकेंडली give a clear meaning or clear definition to certain terms like disturbed area से आप क्या समझते हो. इसको vaguely define कर दिया है. Anyone can declare, government can declare any area as disturbed areas. What do you mean by disturbed area? What are the criteria that any area can be declared as a disturbed area? Armed rebellion, Naxalism, कुछ तो quantifiable चीज डालोगे. या disturbed area तो कुछ भी हो सकता है. ट्रेन पलट गया, disturbed हो गया एरिया. So they have recommended to bring in more clarity to these vague terms. Also, there is a Jeevan Reddy committee. Jeevan Reddy committee. It has recommended. It also has recommended that after consultation with all the stakeholders, government should repeal the APSPA. Government should repeal the APSPA. And if government is continuing with the APSPA, the use of force can only be prescribed or sanctioned by an officer above a particular rank. एक रैंक के ऊपर के ऑफिसर को ही वैसी फोर्स यूज करने की सैंक्शन होनी चाहिए. Apart from it, this committee has told to set up a grievance cell. Grievance cell in every district, that anyone who feels offended by the actions against the APSPA, or anyone who feels aggrieved by any action taken by the armed forces due to APSPA, can approach this district grievance cell. Grievances. Right? But just a second. ठीक है. So this is another area of concern, the deployment of forces, and based upon that there are certain laws also. There is a specific kind of force which is also creating much trouble between union and state. CBI. Everyone's favorite CBI. घोटाले हो गए, CBI बुलाओ. स्टेट वालों से नहीं हो रहा है, CBI बुलाओ. CBI जबरदस्ती कर रही है. CBI फर्जी केस बना रही है. सिसोदिया जी अंदर है. Use of CBI has been one of things which every government has done, irrespective of whatever party in power is there. It cannot be denied that they have not been politically misused. But it can also not be denied that they are far more competent than the local state police in terms of investigation, in terms of their technical expertise. Should CBI be used? Should not CBI be used? What is the manner in which they be used? What are the reforms which can be done in the CBI? Why there is a conflict? So CBI is an agency which is working under the government of India. Ministry of Home Affairs के अंदर उनका कमांड रहता है. CBI is a non-statutory body. It is a non-constitutional body. CBI was originally not CBI. There was an act called Delhi Police Establishment Act. So there was a Delhi Police Establishment which was enacted or which was created for that. अब उसका पर्पस क्या था? Delhi is a union territory. It has the central government employees. So that Delhi Police Special Establishment was given this task to investigate the offenses of corruption in the central government employees. So what is the prime responsibility of DPSE? Delhi Police Special Establishment. Delhi Special Police Establishment. So what is the prime responsibility of this establishment? Is to investigate the crime of corruption which is prevalent among the central government employees. Now later this organization itself was revamped and renamed as Central Bureau of Investigation. So CBI draws its power from the same act, Delhi Special Police Establishment Act. So technically CBI had no jurisdiction to investigate the local crimes. That is the jurisdiction, subject matter of law and order is the subject matter of state. And this is an agency of union. तो हॉलीवुड के मूवी देख के ये नहीं समझना कि FBI है तो कहीं भी घुस सकती है. There is no concept of FBI in India. But should CBI be used or not? What are the situations when CBI can investigate the matter? No, it has not been created by that act. It derives its power from there. But its creation, its functioning, its composition has not been given there. It is subject to time and again it is getting changed by executive notifications. तो अब सीबीआई कैसे केस इन्वेस्टिगेट कर सकती है? कैन सीबीआई इटसेल्फ इन्वेस्टिगेट द केस? जैसे मान लीजिए लोकल पुलिस है, if there is any crime which is occurring at this place, can local police come and start investigation without any FIR? Yes, it can. But can CBI come and start its investigation? It cannot. So CBI cannot take a suo motu investigation. On itself, CBI cannot start investigation. So what are the ways when CBI can start investigation? Only in a few limited cases. Firstly, if there is any central government employee and they may be working in certain states, IRS, Indian Revenue Services, income tax, that is a central services, and those employees are alleged with the crime of corruption, CBI can investigate. But for that matter, CBI needs the consent of the state to enter into their premises and start investigation. One is general consent, another is specific consent. General consent means what? If suppose I am CBI, you people are different states. So one of the states says, if these are certain nature of crime, if these kinds of crime happens, you do not need to seek permission from me. You come and start investigation directly. अब CBI को इन्वेस्टिगेट करने के लिए प्रॉब्लम्स क्या क्या फेस करनी पड़ती है? आक्रोश मूवी देखा है किसी ने? Movies example can relate more. आक्रोश इज अ मूवी. अच्छा, ये सब जो मूवी का मैं नाम लेके देखता हूँ नहीं, रिकमेंडेशन नहीं है घर जाकर देखने की. आप लोग अपना टाइम इधर ना लगाएं, मैं उसका कॉन्टेक्स्ट एक्सप्लेन कर देता हूँ. So there is a scene. There are two CBI officers, अजय देवगन, अक्षय खन्ना है, and there is a case related to honor killings on बिहार में. तो ऑनर किलिंग्स का केस है, बजरंग सेना टाइप की कोई सेना है उधर, एंड दे आर डूइंग ऑनर किलिंग. उधर क्या कौन सेना है? रणवीर सेना. तो ऐसे कोई सेना, उन्होंने नाम भी वैसे सेना रखा हुआ है. तो देयर इज अ स्टूडेंट ऑफ JNU हु बिलोंग टू बिहार, एंड व्हेन शी विजिटेड बिहार ही वाज किल्ड अलोंग विद हिज फ्रेंड. तो अब एक दिल्ली का भी लड़का था, तो उसकी खोज भी इन्होंने ली, कहाँ गया कहाँ गया कहाँ गया. तो मैटर देन फाइनली केम टू द CBI. नाउ CBI इज गोइंग, दे विल नीड टू शेयर द एविडेंसेस फ्रॉम लोकल पुलिस. पुलिस वाला खुद सेना का मेंबर है, वो उसको बैठने तक का ऑफिस नहीं देता. CBI needs to set up their office so that the team can start working, and all of these needs the resources to be shared by the state. So the first problem what CBI is facing, transmission of the information, setting of their office, and sharing of the information. ये स्टेट की मशीनरी से कॉपरेशन सीबीआई को नहीं मिलता है, स्पेशली इफ देयर इज अदर पॉलिटिकल पार्टीज एट द पावर. स्टेट पुलिस विल बी of course working on that particular under the command of the state government, so they will be showing particular characteristics. महाराष्ट्र के एग्जांपल ले लो आप. When CBI went on to started investigating सुशांत सिंह मर्डर केस, सुशांत सिंह राजपूत जो हीरो हुआ था, मर्डर या सुसाइड केस जो भी बोलो. So what CBI initially faced this problem because that time the party in center and party in Maharashtra both were different. So CBI repeatedly told this thing that we are not getting full cooperation from the state police. And coming from Delhi and going into a different state and then starting the investigation is a big challenge. Now again you can relate with the Arushi Talwar case. Why it is important to get the support of the local police. Once CBI reached to the crime spot, they observed that the most of the evidences has been spoiled by the local police. So CBI needs what? Firstly, either general consent or specific consent. General consent means if the state has given a general consent that in these kinds of cases, you do not need to seek my permission every time. You can come and start investigation. Our machinery will be supporting you. Specific consent means the state has not given them general consent. Every time CBI needs to send a letter that I want to start investigation, and if states give the consent, then they can start investigation. So this is first way when CBI can start investigation. Secondly, if the courts ordered the CBI, High Court, Supreme Court, if they orders the CBI to take up any particular investigation cases, Chara Ghotala scam. So if court orders to take up any investigation, the CBI can start investigation. Or third, if state government themselves approaches the Ministry of Home Affairs, कि भैया मेरे पुलिस के बस की बात ना है, दे दो कुछ. So if state government approaches the union to give the help of CBI, then CBI can take up the investigation. So these are the ways. Now why CBI is getting alleged? Because so far until now the CBI has been revamped. There is a greater role of other Lokpal and Central Vigilance Commissioner in appointment of director of the CBI. Now CBI director, he will be heading the administration of the CBI, and they were not having the security of tenure. They can be changed at any point of time by the Ministry of Home Affairs. So firstly, even if there is an iota of thing that CBI has started to investigate any case against the party in power at the center, change the director. There was a widespread controversy out in the public between two directors of the CBI. One was removed, other was instituted in place of that. I am forgetting the name. One was Mr. Alok Kumar. Rakesh Asthana. Delhi. So it was fully under the control of Ministry of Home Affairs. Now even Supreme Court has remarked a statement against CBI. CBI is a caged parrot which speaks only of its master. And it is a no doubt that who is the master of the CBI is the union government. So whenever CBI will start an investigation and you will find the interest of the state government is different, there will be allegations and cross allegations. So state government will be accusing that union is trying to use CBI against our personals. Like now only you can find Kejriwal is telling that central government मुझे 10 दिन के लिए ED दे दो, मुझे 10 दिन के लिए CBI दे दो, मैं ये कर दूंगा वो कर दूंगा. This means he is trying to indicate that union government is misusing CBI, ED, all these central agencies, trying to start investigation in fake cases against their ministers or their personnel. So this is another bone of contention, CBI related, right? So these are certain issues. There are other issues also in the administrative relationship, but उसके लिए आपको जरूरत पड़ेगी notes. Remaining issues will take up tomorrow, but ऐसा नहीं कि हम खत्म कर रहे हैं. We are moving from administrative, we are coming to the financial relationship. ठीक है, ये तो मुझे सिर्फ बेसिक्स बताना था, मैं फ्लो में कुछ ज्यादा बह गया. Then I suddenly realized कि आप लोगों के पास नोट्स नहीं है. फाइनेंशियल रिलेशनशिप बिटवीन यूनियन एंड स्टेट्स. नाउ दिस विल बी कंसर्निंग अबाउट एलोकेशन ऑफ टैक्सेस. अब उससे पहले दो तीन चीजें आपको टर्म समझनी होगी. वन इज लेवी ऑफ टैक्सेस, अनदर इज एप्रोप्रिएशन ऑफ टैक्सेस, and another is collection of taxes. Levy means imposing the tax, charging the tax. Who can charge the tax? Collection means who can collect the tax. Suppose that I am the state government, you are the central government, and there are certain persons. Those persons are doing business in the state. Those taxes are being charged by the union government. But do you think union will directly come and collect there? It may come, it may also give the power to the state to collect and give it to the center. So these three things are different things. Levying means who is imposing the tax. Collection means who is collecting the tax. And appropriation means who is finally using the tax. Right? अब यही है फाइनेंशियल रिलेशनशिप का बेसिस. Certain tax can be charged by the union, collected and used by the states. Certain tax which is charged, collected by the union, given to the states. Certain tax which are charged by the union, collected by the union and shared between union and states. तो वो कौन से ऐसे टैक्सेस हैं? Secondly, there is a recognized principle under the constitution that no authority except which has been given the permission by the law can levy a tax. इस देश में अगर कोई भी अथॉरिटी ऐसी है जो विदाउट एनी लॉ दे इम्पोजेस द टैक्स, उसको टैक्स यानी रंगदारी बोलते हैं. टैक्स कैन ओनली बी imposed by any authority which has got a backing of the law. Without the law, no tax can be imposed in India. Who can create the laws for the tax? It is as simple. Any matter which is given under the union list and that requires taxation, Parliament can make laws for that. मैं लॉ बनाने की बात कर रहा हूं. टैक्स कलेक्ट कौन करेगा, लेवी कौन करेगा, इसकी बात पे अभी मैं नहीं आया हूं. So any matter which is given under the union list and that requires the taxation, Parliament can make the law. Any matter which is given under the state list and that requires taxation, the state legislature can make the law on that to create to levy taxes. उसके ऊपर कानून कौन बना सकता है? जैसे लैंड रेवेन्यू, it is under the state list. So if land revenue tax is to be collected, state legislature will enact the laws for that. Okay. Or any matter which is given under the concurrent list, who can make the laws? Both union and state can make the law. The residuary power of taxation is in the hands of Parliament. So this is a kind of a legislative distribution only, but specific to the taxation. टैक्स वाले लॉ कौन बना सकता है? तो अपने अपने लिस्ट में वो लोग सारे टैक्स बना सकते, लॉज बना सकते हैं. राइट नाउ किस तरह के टैक्सेस कौन कलेक्ट करेगा? सबसे पहले देयर आर सर्टेन टैक्सेस व्हिच इज गिवन अंडर आर्टिकल 268. सो आर्टिकल 268 सेज देयर मे बी सर्टेन टैक्सेस व्हिच इज लेविड बाय द सेंटर, व्हिच इज लेविड बाय द सेंटर, बट दे आर कलेक्टेड एंड अप्रोप्रिएटेड बाय द स्टेट्स. Who is levying that? Center. And collect states and use कौन कर रहा है उसको? States. So these will be the taxes. Example, taxes on promissory notes, bill of exchange, checks. इन सब पेमेंट के ऊपर जो भी टैक्सेस लगाए जा रहे हैं, these are charged by the central government. But who is collecting that from you? States. Who is using that money? States. This is provided under 268. Now 269 provides there are certain taxes which are levied and collected by the union, but they are assigned to the states. लेवी कौन कर रहा है? यूनियन. कलेक्ट कौन कर रहा है? यूनियन. और असाइन किसको कर दिया उसने कलेक्ट करने के बाद? स्टेट्स को. फॉर एग्जाम्पल, लेट्स टेक एन एग्जाम्पल. मैगी बन रही है. मैगी का गेहूं कहां प्रोड्यूस हो रहा है? मैदे का बनता है. मैदा किसी का? बाजरे का बनता है. केक बना रहे हैं, केक का आटा आ रहा है, वो इसमें तो मैदा है, कुछ भी बना रहे हैं, अगरबत्ती बना रहे हैं, है ना? हाँ, समोसे, समोसे में मैदा आ गया यार। मैदा किसका बन रहा है ये नहीं पता कर पा रहे हो? पता नहीं, जिस भी चीज का बनता होगा। नहीं खाना चाहिए मैदा। चॉकलेट बना लें? हाँ, चॉकलेट बन रहा है, कोकोआ सीड से बनेगा। अब वो हम इंपोर्ट कर रहे हैं बात। मान लो कि एक गुड्स है, लेदर जैकेट बना रहा है कानपुर में, ठीक है? ये तो पता है कहाँ बनता है। तो देयर इज अ लेदर शू और लेदर जैकेट बीइंग मैन्युफैक्चर्ड इन कानपुर। कानपुर ने बनाया, अब वाया एमपी इट इज बीइंग सोल्ड इन कर्नाटका। तो मैन्युफैक्चरिंग यूपी, ट्रांसपोर्ट एमपी, कंजम्पशन कर्नाटका। Who shall impose the tax? Which state shall impose the tax? एमपी। तो रंगदारी हो गया ना भाई, मेरा रास्ता यूज कर रहे हो तो मुझे टैक्स दो। हाँ, अच्छा, किस प्रोपोर्शन में? Who will decide this proportion? यही तो डिस्प्यूट है। इफ यू लीव इट अपॉन द स्टेट्स, वो आपस में लड़ बनेंगे। यूपी विल से नो, विदाउट माई प्रोडक्शन आपके ट्रांसपोर्ट की जरूरत ही नहीं है। कर्नाटका विल से अच्छा, फॉर कीप ऑन प्रोड्यूसिंग आई विल नॉट कंज्यूम। एमपी विल से ओके, तुम प्रोड्यूस करो, तुम कंज्यूम करो, देखो कैसे ले जाते हैं। सो दिस इज वाई union government will impose the tax. Union government will levy the tax. These are the tax which are the part of interstate trade and commerce. ये यहाँ क्या हो रहा है? What I mean to signify is interstate trade and commerce. Now this interstate trade commerce, the taxes upon this are levied by union, collected by union, and union will allocate along with in सब states में they will distribute, assign कर देंगे as per their respective shares. जितना शेयर जिसको बनता है उतना शेयर उसको चला जाएगा. So this is under 269. Now under Article 269 there has been amendment. Amendment कब हुआ है? 101st Amendment Act, GST. So after 269 there is 269A which has been added to our constitution. This has been added by 101 amendment and this is GST amendment. Right? So GST में तीन तरह की GST होती है. कभी जाओ डोमिनोज में पिज्जा खाने, you will find CGST, you will find SGST and you will find IGST. So this interstate goods and services, this is now being into every goods and services is now the part of GST, barring few. कुछ ऐसी चीजें हैं जो अभी भी GST से बाहर हैं. So all those goods and services which were subsumed under the GST but still talks about interstate transfer of goods or services, those are under the part of IGST, integrated goods and services tax. That IGST is getting collected by the union on the same proportion, is levied by the union, collected by the union, but shared by different state. And at what proportion? The proportion is decided by GST Council. So 101 amendment added this 269A and it also added 279A to the constitution. This 279A talks about creation of GST Council. Article 279A talks about the creation of GST Council. Now GST Council is one of the platform which was thought to promote the cooperative federalism in India. Cooperative federalism means where union and state are cooperating with each other, they are not conflicting with each other. Where different states are sitting on the same table and they are cooperating with each other. So GST Council was thought to be the harbinger of this cooperative federalism in India. However, due to party politics, it has not been able to realize its full potential. Who are the part of the GST Council? So you should note that GST Council is chaired by the Finance Minister of Union. नॉट द प्राइम मिनिस्टर। इस कंफ्यूजन में आपको नहीं रहना है। तो जीएसटी काउंसिल विल बी चेयर्ड बाय द फाइनेंस मिनिस्टर ऑफ यूनियन एंड टू सपोर्ट हिम द मिनिस्टर ऑफ स्टेट ऑफ द डिपार्टमेंट ऑफ रेवेन्यू। फाइनेंस मिनिस्टर में बहुत सारे डिपार्टमेंट्स होंगे, तो वन ऑफ द डिपार्टमेंट इज डिपार्टमेंट ऑफ रेवेन्यू, दैट विल बी लेड बाय मिनिस्टर ऑफ स्टेट, और उसका मिनिस्टर ऑफ स्टेट जो होगा ही विल आल्सो बी द पार्ट ऑफ जीएसटी काउंसिल। नाउ जीएसटी काउंसिल विल आल्सो इंक्लूड whom? द डिफरेंट मिनिस्टर ऑफ फाइनेंस। हर स्टेट का जो फाइनेंस मिनिस्टर होता है, और इधर ही, और चीफ मिनिस्टर अगर खुद ही है तो खुद आ जाए, और ही हिमसेल्फ इज द फाइनेंस मिनिस्टर। बहुत स्टेट्स में चीफ मिनिस्टर या फाइनेंस मिनिस्टर होता है, तो ही विल थिंक कि मैं यूनियन होम मिनिस्टर जाऊंगा मिलने, मैं चीफ मिनिस्टर हूँ, वो होम ये फाइनेंस मिनिस्टर है, आई एम बिगर अ पॉलिटिशियन देन हिम। जैसे मान लो योगी जी को आना हुआ निर्मला सीतारमन से मिलने को, कहेंगे मैं जाऊंगा, सो ही कैन नॉमिनेट एनी अदर पर्सन। सो बेसिकली दे हैव, जीएसटी काउंसिल हैज ए रिप्रेजेंटेटिव मिनिस्टर कमिंग फ्रॉम द स्टेट। तो स्टेट और यूनियन को मिला के एक फोरम बनी जीएसटी काउंसिल। Now this GST council is responsible for taking certain functions, like what are the taxes, what are the products which will be the part of GST, what are the products or services which will not be part of the GST, what are the different tax slab, 5%, 12%, 18%, 28%. Can this tax slab be changed? Can this tax slab be increased? 5 को हम 6 कर दे. What are the goods and services upon which GST are exempted? तो ऐसी कई सारी सर्विसेज को बढ़ाना एंड बताना कि किस पे टैक्स लगेगा, किस पे नहीं लगेगा. दिस विल बी डन एज पर द डिसीजन ऑफ जीएसटी काउंसिल. नाउ हाउ जीएसटी काउंसिल डिसाइड्स? इट डिसाइड्स ऑन द बेसिस ऑफ मेजॉरिटी वोट्स. तो मेजॉरिटी करने के लिए हाउ मच वोट इज रिक्वायर्ड? 3/4 मेजॉरिटी इज रिक्वायर्ड. 3/4 मेजॉरिटी के साथ डिसीजन लिया जाता है. राइट? So this is GST Council which has been further created by 279. इसका मैं नोट्स दे दूंगा when we will be doing that ना, कॉन्स्टिट्यूशनल बॉडीज वाला, फाइनेंस कमीशन, जीएसटी काउंसिल, उन सब के डिटेल उसमें है मेंशन, टेबल बना के. राइट? So in order to facilitate this kinds of interstate goods and services transaction, we have now GST Council and we use integrated GST. Now there may be one another tax which is given under Article 270. So Article 270 says any taxes which is not covered in 268, 269, वो कहां पे आएंगे? 270 में. They can be levied by the union, collected by the union and appropriated by union. अकेला कोई टैक्स अप्रोप्रिएट नहीं करता. Under 270, who will levy? Union. Who will collect? Union. And these taxes will be distributed between union and states. For example, income tax, for example, corporate tax. Union levy करेगा. Income tax कौन चार्ज करता है आपसे? यूनियन गवर्नमेंट. डिपार्टमेंट ऑफ इनकम टैक्स किसकी है? यूनियन की है. अभी आईटीआर भरा जा रहा है तो यूनियन गवर्नमेंट की डिपार्टमेंट है, डिपार्टमेंट ऑफ इनकम टैक्स. तो देयर इज सेंट्रल ब्यूरो, सेंट्रल बोर्ड ऑफ डायरेक्ट टैक्सेस, और जीएसटी वगैरह के लिए सेंट्रल बोर्ड ऑफ इनडायरेक्ट टैक्सेस है. पहले वो सेंट्रल बोर्ड ऑफ एक्साइज कस्टम था, उसको अब सेंट्रल बोर्ड ऑफ इनडायरेक्ट टैक्सेस कर दिया. सो यूनियन विल कलेक्ट द डायरेक्ट टैक्स फ्रॉम यू. इट विल लेवी, इट विल कलेक्ट, and these collected will come to the consolidated fund of India. See, these funds which were appropriated by the states, they were not the part of consolidated fund of India, they were the part of consolidated fund of states. सेंटर तक तो पैसे पहुंचे ही नहीं, ये पैसा सेंटर तक पहुंच रहा है. यूनियन इज कलेक्टिंग, यूनियन इज कीपिंग विद इटसेल्फ. Then in order to distribute the revenues out of consolidated fund of India, कुछ पोर्शन यूनियन रखेगा, कुछ पोर्शन स्टेट्स को दे देगा, बेस्ड अपॉन द रिकमेंडेशन ऑफ फाइनेंस कमीशन. सो इन ऑर्डर टू रिकमेंड दिस डेवोल्यूशन ऑफ फाइनेंसेस फ्रॉम यूनियन टू स्टेट्स, we have this body created under Article 280 as Finance Commission of India, right? So this Finance Commission will recommend on the principles through which this finances from union will be shared to the states, right? Now these are the tax sharing mechanism, the financial relationship between union and state. Remember, जब फाइनेंशियल इमरजेंसी लग जाएगा, ये सारा फाइनेंशियल रिलेशनशिप धरा का धरा रह जाएगा. This financial relationship can be altered during the time of financial emergency. Apart from it, so these are the sharing of taxes. Apart from it, union can also give certain other helps to the state. कुछ और पैसे चाहिए स्टेट को, ले जाओ भाई. Those are called grant in aids. क्या कहते हैं? Grant in aids. सहायता राशि, सहायता अनुदान. Or you can call statutory grants, right? And there is another kinds of grant that is called discretionary grants. फाइनेंस कमीशन, जो फाइनेंस कमीशन बनता है, एक काम तो करता है, इट विल टॉक अबाउट द शेयरिंग ऑफ टैक्सेस बिटवीन यूनियन एंड स्टेट, बट इट विल ऑल्सो recommend those principles through which the grant in aids can be given to the different states. So there is Article 275 which talks about grant in aids. अगर मान लीजिए किसी स्टेट में there is some state which is backward states that may require additional sum, वहां पे जीडीपी कम है, पिछड़ापन जाता है, ट्राइबल एरिया ज्यादा है. So for that purpose, grant in aids can be given by the union to the state. ये ले जा भाई, इतने पैसे वापस मत करना, enjoy, have a dinner. So this is the power of union, they can give, but based upon the principle which is recommended by the finance commission. Even beyond this, अगर सेंटर को मन कर रहा है और भी किसी स्टेट को पैसा दे, तो उसके लिए डिस्क्रिशनरी ग्रांट है, वो अपनी मर्जी से किसी स्टेट को पैसा दे. बाढ़ है आपके यहाँ, ले जाओ. अच्छा, आप हमको वोट दिलाओगे, ले जाओ. तो डिस्क्रिशनरी ग्रांट इज गिवन अंडर आर्टिकल 282 ऑफ द कॉन्स्टिट्यूशन. Discretionary grant can be for any specific or general purposes. Even that matter is not under the legislative competence of parliament. Police is not under the legislative competence of parliament. अब गोवा में पुलिस की दिक्कत हो, ले भाई 100 करोड़ रुपए, पुलिस संभाल ले अपना. It is not the work of parliament, but still union can give that money. Right? So these are the methods and avenues of sharing the resources, devolution of finances from union to states. ठीक है? अब इसमें प्रॉब्लम कहां आएगी? फाइनेंस कमीशन ने कुछ रिकमेंडेशन दी, यूनियन विल नॉट डिवॉल्व दैट मच, कुछ पैसे रोक लेंगे. नाउ सम स्टेट्स विल से, भाई महाराष्ट्र को भी उतना ही दे रहे हो, उसका हाई जीडीपी है, मुझे भी उतनी ही दे रहे हो, मुझे थोड़ा और दे दो, गिव मी स्पेशल कैटेगरी. तो स्पेशल कैटेगरी स्टेट्स को ज्यादा मिलता है, हिमालयन स्टेट्स को ज्यादा मिलता है. Until and unless Jammu Kashmir was the state that was the recipient of one of the highest recipient of these grants by the union government, but still there could not be tangible development there due to certain distracting factors.